I'm very pleased to welcome a barrister, Sam Way, onto the channel. Sam is a barrister from Devereux Chambers, and one of his key practice areas is employment law. Thank you so much for joining me, Sam.
Hi, Matt. Thanks so much for having me on the channel. I think what you're doing is a really important project. Employment law can often seem impenetrable, and so to have these bite-sized explanations hopefully makes the concepts that you and I deal with on a day-to-day basis easier for people to understand. We're going to talk today about a case which decided something of importance to a lot of these topics. That's a case called Royal Mail Group Limited and Jhuti, and it tells tribunals whose reasons for a dismissal they're required to analyse for the purpose of unfair dismissal claims.
Sam, as this case concerns whistleblowing, are you able just to explain the law on whistleblowing briefly?
The law protects whistleblowers who are dismissed or subjected to any other detriment on the ground that they have made what's called a protected disclosure. To be a protected disclosure, the worker must have disclosed information which, in the reasonable belief of that worker, tends to show that at least one of various things, such as, for example, a criminal offence or a breach of a legal obligation has taken place, is taking place, or is likely to take place. The worker must also reasonably believe that the disclosure is in the public interest. If that person is then subjected to a detriment or they're dismissed because of the protected disclosure, then they can make a claim in the employment tribunal. For employees bringing unfair dismissal claims, if they have been dismissed, then that dismissal is automatically unfair. An important consequence of this is that the employee does not need to have had the 2 years minimum service that's required for ordinary unfair dismissal claims. There's also no cap on the award, which there is for an ordinary unfair dismissal claim.
Thanks, Sam. So what are the particular facts of this case?
Mrs. Jhuti worked as a media specialist in Royal Mail's sales division. She was on probation at the time, and she observed her colleagues offering their customers tailor-made incentives, which were prohibited by the regulator due to the Royal Mail's dominant position in the market. She did what any good employee would do and raised her concerns about this with her manager, thereby making a protected disclosure. Rather than deal with those allegations, her manager pushed back against them. He invited her to a meeting where he made it clear to her that she was on trial and that the allegations could cause problems for everyone. Mrs. Jhuti did what many employees would do in that situation, where it had been made clear to her that her employment would be at risk if she pursued those allegations, and she withdrew them. She even apologised to her manager for making the allegations in the first place. So quite extraordinary to start with, but even more extraordinarily, Mrs. Jhuti's manager then proceeded to impose very harsh performance targets on her, which were not imposed on any other employees. The clear implication being that those targets were imposed because of the protected disclosure she had made. This understandably caused Mrs. Jhuti a great deal of stress, and she was signed off work. But while she was signed off, the performance management continued. A different manager was then appointed to decide whether or not Mrs. Jhuti should be dismissed for not meeting the targets. Now, that different manager decided, in entirely good faith, that Mrs. Jhuti had not complied with the performance management obligations and that she should be dismissed. So the issue the tribunal had to decide was whether the reason for the dismissal was the decision to impose performance management targets, which had been made because of the protected disclosure, or whether it was the separate and entirely innocent decision that Mrs. Jhuti had not complied with those targets.
So how was the case decided? There was, of course, the employment tribunal decision, but then there were also various appeals.
Well, I think it's fair to say that the decisions of the lower courts bounced back and forth. The Employment Tribunal held that the reason for the dismissal was not the fact that the performance management targets had been imposed, and therefore it wasn't as a result of the protected disclosures. The dismissing officer did not know that the reason the targets had been applied was because of the protected disclosures, and genuinely believed that Mrs. Jhuti's performance was inadequate. The Employment Appeal Tribunal allowed an appeal by Mrs. Jhuti, finding that if someone in a managerial position who's responsible for the employee had manipulated a decision to dismiss her, which had been made in ignorance of that manipulation, then the manipulator's reason for dismissal can be attributed to the employer. So the Employment Appeal Tribunal therefore found that the reason for Mrs. Jhuti's dismissal was that she had been put on an unfair performance management program in response to the protected disclosures she made. The Court of Appeal allowed an appeal by Royal Mail, holding that the tribunal was obliged to consider only the mental processes of the person who was authorised to, and did, take the decision to dismiss. Because the dismissing manager did not know that the performance targets were imposed because Mrs. Jhuti had made protected disclosures, the Court of Appeal therefore found that the decision to dismiss was therefore not because of those protected disclosures.
Interesting, Sam. And what was the final twist?
The Supreme Court reversed the decision again. It held that the question that had to be decided was a common question that arises when dealing with companies. Which human being is taken to have the state of mind which then falls to be attributed to the company when the company makes a decision? It noted that the answer to this question varies according to the context in which it's asked. The important question was therefore how to identify the reason for a company's dismissal of an employee. The court placed particular importance on the fact that employment law must function in the real world. So it would be an unduly technical response to limited employment tribunal's analysis only to the state of the mind of the person who actually made the decision to dismiss, where there's obvious manipulation going on behind the scenes. In that scenario, the company's reason can go beyond the reason of the person who actually made the decision to dismiss. The company's reason will include the additional circumstances which the manager operating behind the scenes has brought about. So, to summarise in quite plain language, the Supreme Court held that if the reason given for a dismissal can be shown to be bogus, then the tribunal can look to the real reason for the dismissal, even if the dismissing person knows nothing about it.
It looks like, Sam, that even when a reason for dismissal is adopted in good faith, the tribunal should penetrate through that reason and look lower down the management hierarchy to find the real reason for dismissal. Are there not wider implications for the decision?
Yes, Matt, absolutely. The decision explains how to find the identity of the employer for unfair dismissal purposes, and hence whose mental processes have to be analysed to determine the reason for the decision that's been made. Most obviously, this is a principle that doesn't just apply to whistleblowing unfair dismissal claims. It applies to claims for ordinary unfair dismissal as well, where the employer must establish that the reason for the dismissal is one of the potentially fair reasons allowed, such as, for example, capability, misconduct, and redundancy.
What about discrimination claims? It must be about looking behind the decision to see whether the decision was discriminatory.
Yes, it's easy to see how this principle would extend to discrimination claims as well. It's about how to determine who is the employer for the purposes of determining whether an employee's statutory rights have been violated. discrimination claims equally call for an analysis of the mental processes underpinning decisions that have been made. And so if a similar situation were to arise in which there were a background actor manipulating the apparent decision maker, it's the mental processes of the person in the background that should be examined to decide whether the decision was discriminatory. However, I think it's important not to get carried away with this decision. It's very common in my experience for people to bring claims alleging that their employer was operating some sort of vast conspiracy against them. But what this decision shows is how exceptional the facts would have to be before a tribunal will look behind the obvious explanation given by an employer for their decision.
And Sam, are there any practical considerations for employers?
Yes, it's important that where a decision maker is being asked to adopt another manager's decision, they are alive to the fact that the original decision might be improper. So to take the example of Mrs. Jhuti, the dismissing manager was asked to decide whether she had met the performance requirements that had been imposed on her. If that manager had questioned why those requirements had been imposed in the first place, then it's likely that she would have identified that they were imposed for an improper reason, because Mrs. Jhuti had made a protected disclosure. It's not sufficient for a dismissing manager simply to assume that everything their colleagues have done was for the right reasons. So employees should therefore train managers who are conducting disciplinary hearings in particular to make sure that they ask the right questions and probe where necessary into the basis for the disciplinary processes that they're a part of.
Sam, that's great. Thank you so much for explaining such an important case and coming on the channel.
Thanks very much, Matt. Great to be here.
Well, I hope you all found that video useful. For more information on whistleblowing, unfair dismissal, and discrimination, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to this channel for updates.